That's not even why we talk. We've got cases, 3 cases, the good cases. And for November, I decided I'd pick on the Board of Immigration Appeals only because the circuits and the Attorney General picked on the Board of Immigration Appeals. So 3 cases. First, Laparra-Deleon v. Garland out of the first on November 4th, 2022. This is the First Circuit vacating Matter of Lapara. Same case title, Laparra-Deleon. It's Matter of Lapara, which was the board's in absentia motion to reopen decision, where they said, essentially, that even if the notice to appear is deficient, doesn't have the date, time, or location of the first hearing, and that's what starts the removal proceedings, and then the non-citizen is ordered removed in absentia. Even if you got a deficient NTA, you still have to show that you didn't receive the notice of hearing or that you provided an address. The same in absentia motion to reopen framework, really, that you've always had. Pereira and Chavez, we don't care, said the board in Matter of Lapara. The thing is that the in absentia reopening statute itself, unlike some of these other statutes where the deficient NTA issues are getting brought up, the in absentia reopening statute expressly links up to INA Section 239A, which is the statute that defines a notice to appear. So it's a pretty similar logic, almost identical logic to the one being used by the Supreme Court in Pereira and Ms. Chavez with the stop time rule, but just in an absentia reopening. They all link up to INA Section 239A, and to me, and to Justice Gorsuch, and to a lot of judges, if you're linking 239A into the statute, then you have a statutory requirement to comply and to provide a compliant notice to appear. Mm-hmm. The in absentia reopening statute does that. Matter of Lapara apparently arose in the First Circuit, so the First Circuit got it on direct petition for review and vacated it, saying the text is the text. They didn't quite say you have to reopen this in absentia order. They sent it back for other analysis, but Matter of Lapara is vacated. It seems like it's the First Circuit is agreeing with the Ninth Circuit in Singh to say a deficient NTA needs to be reopened if it's an absentia order removal premised on a deficient NTA needs to be reopened. And again, that's now the First Circuit and the Ninth Circuit. These are thousands and thousands of in absentia removal orders issued since 1997 based on deficient NTAs. And these individuals, I don't know, maybe they're married to U.S. citizens now, that maybe they are adjustment eligible to get this. Maybe they need to go and consular process. But the in absentia removal order was an unwaivable 5-year bar, for example. So these things are crazy.
Like, it seems like all the circuit courts are going on the side of these deficient notices being a problem. And it's only the BIA who's like not doing that.
Unfortunately, that's not true. There's a complete circuit split, and I've been talking about it on my show. It's got to go to the Supreme Court next term. It really has to, because this is, of course, a Supreme Court creation. But you know, it's a DHS not complying with INA 239A for 25 years creation. But the 11th Circuit has flat out said the opposite. The 11th Circuit is, we don't care.
Oh, okay.
In absentia reopening. You got to show notice of hearing. Same thing we always had to show. The 5th Circuit, which is the other border circuit in addition to the 9th, is all over the place. First, they issued the Rodriguez decision. They were the first circuit to touch this. It was crazy. And it was the 5th. And they were essentially, and as I read Rodriguez, they're saying you got to reopen these. And it's the 5th Circuit. Like Harlingen has ordered, half the country ordered removed in absentia. I mean, it's crazy. And that was like the dream period for a couple months. And then different panels in the 5th started chipping away at Rodriguez, Spagno, Bastos, a variety of cases. There was a decision just last week where the chief judge issued a concurrence to explain the chaos that is his absentia reopening in the 5th Circuit. And now, essentially in the 5th, you have to show that the non-citizen provided DHS, USCIS, UAR, whatever, with a proper address. So it's not so much, as I read it, that you have to show that you didn't receive the notice of hearing, like always used to be the case, but you have to show that you provided a proper address. It's going to be difficult to do all these decades later.
Yeah.
And that is based on another statute. To be honest, as I said on my show, I don't quite see how that really is important when it's the in absentia reopening statute linking up to 239A. The First Circuit addresses this issue. The Ninth Circuit addresses this issue. I mean, the First and the Ninth say the opposite. The Fifth Circuit in Rodriguez shot down an en banc challenge in Rodriguez. So one would think that all of this was kind of resolved in the Fifth, but the chief judge essentially said this wasn't argued in last week. The chief judge said this wasn't argued in Rodriguez, so I don't even know if Rodriguez is good law, which is not how it works, but that was a concurrence. And obviously many judges in the Fifth don't like Rodriguez. Anyway, the Fifth is all over the place. The 11th is on the other side. The board said Matter of Lapara. The First and the Ninth on the other side of reopening. I would argue, as I've argued so often on the podcast, and I might even have a note on this issue soon with a great intern we had, that Matter of Lapara is now zombie precedent, that it shouldn't exist anywhere because Matter of Lapara itself arose in the First Circuit, and then the First Circuit vacated it. There does not exist a Matter of Lapara anymore. It's not the same as when, the Ninth Circuit, as it did in Singh, refuses to defer to Lapara.
Yeah.
But then it doesn't apply in the Ninth, but it applies everywhere else. But in this case, the First Circuit says Matter of Lapara, you don't exist anymore. Vacated. I would argue it doesn't exist anywhere. Nobody else makes that argument, so I guess I'm wrong, but I don't know why I'm wrong. So I'm going to keep arguing it.
Keep up the good fight.
So that is deficient NTAs. Much more on that than you probably wanted to hear, but I can't talk about deficient NTA motions to reopen in absentia without going down that path anymore. It's got to be on the docket next term. It's got to be. And who knows? I mean, Pereira was 8-1 with only, I want to say, Alito in dissent. Ms. Chavez was, I believe, 6-3. So they were with Ms. Chavez with, the notice of hearing issued. The court was like, I don't know. So now that we'll have in absentia reopening, when there are literally, 500,000 in absentia removal orders at issue, we'll see what the court says. But that shouldn't matter. We're a textualist court, right? The text is what it is. If the Supreme Court goes against the Ninth and the First, it'll probably be with the rationale that the Fifth just used. But last week, which I'll get to maybe next month on your podcast.
Let's do it.